Buckle up, because this courtroom case has everything: drugs, deception, a mom of three, and a judge who's absolutely had enough. Molly Fox walks into court with 3 prior cocaine violations, a defense lawyer playing the sympathy card, and a story that's, well, let's just say slippery. But here's the twist: she voluntarily joined a recovery program. Admirable maybe, but now, she's tested positive again. Is this just a slip-up or a calculated move to manipulate the system? You're about to find out. In today's breakdown, we're diving into the People v. Molly Fox case, where addiction, accountability, and motherhood collide under the unforgiving gaze of the court. And stick around, because the judge doesn't hold back, and neither will we. Let's get into it.
Court does call the case People versus Molly Fox.
Good afternoon, Your Honor. Ellen Dennis, appearing on behalf of Molly Fox.
Says the court received a bond violation.
Oh,
Have you seen it, counsel?
yes, Your Honor, I have seen it.
She's positive for cocaine.
Right.
Let's pause right there. Testing positive for cocaine is a big deal, especially in a case where previous violations have already occurred. And no, the court isn't just casually mentioning this. This is the 3rd strike, and that shifts the tone completely. In legal terms, repeated violations can trigger a revocation of bond and even result in pretrial detention. The defense may call it an anomaly, but the court is hearing a pattern.
Your Honor, when the bond was set, I wasn't actually present when the bond was set, but at that point, I think they all agreed that her major problem was that alcohol. That was why she entered a recovery program through community corrections. And she's also been attending AA. Now, she's not been positive for, as I understand it, she's not been positive for alcohol use since that time. This cocaine use is kind of, I don't know, an anomaly. And it seems from my discussion with my client, it's kind of situational, and she realizes that this is absolutely unacceptable.
Quick question for you watching. Is this really a moment of realization, or just damage control? Comment below. Would you trust someone who repeatedly violates court orders but suddenly claims to understand the gravity? Because that's what we're hearing right now, a 3rd violation being framed as a learning moment. Is that believable or just legally convenient?
Absolutely
She
unacceptable.
had another anomaly back in March.
Right, I understand. But what I mean is, it's not, unlike the alcohol, it was not the dominant problem. And yet it is a problem, of course, but it stems, I'm told, from a friendship that she has with somebody that she's had for many, many years. And apparently this other person got into cocaine use, and she would sometimes participate when she was with that person. She realizes she has to break off all contact with this friend because it's apparently evolved into a relationship in which cocaine is customarily used. So we would ask, of course, that bond be continued.
Now, this is a smart move by the defense. By requesting a tether, especially a drug monitoring one, they're trying to show the court that Molly is willing to be watched closely. Problem: most tethers don't even detect cocaine. So the suggestion sounds like a solution, but in reality, it's a half measure. Judges know that. Lawyers know that. You should
Bond be
too.
continued, and if the court thought it was appropriate, she could be put on a tether. She has been going to, she had 8 weeks of first phase recovery program, and she'd started the 2nd phase prior to this cocaine use. And she also has been going to AA once a week in addition. So the recovery program, I guess I would have to say, has been partially successful. And we would like to have an opportunity for her to continue to work on her recovery through that. And I know Mr. Kennedy and I have talked about possibility of resolving the case through recovery court, but he's not sure that she's eligible. And I've been waiting to find out if that's true, because that might very well be a good resolution. So, and in the meantime, I mean, she is the caregiver for...
This is where things get complicated. Molly's a mom of 3, and that matters. Judges don't want to hurt families. But let's be real, being a parent doesn't give you immunity from consequences. So ask yourself, should caregiving override consistent drug violations, or is that exactly why the court must act firmly?
Three minor children, ages 10 and 5. They're all her children. And her significant other with whom she lives, he works full time for one of the car companies, I forget which, for Ford, and is gone in the daytime. So caring for the children, especially when school gets out, which will be pretty soon now, would be very difficult without her presence. But so of course, we're asking for bond to be continued or possibly be modified to provide for her to have an alcohol drug tether. I might also say, I think my understanding is that she entered the recovery program voluntarily. That was not a bond condition. Is that correct?
It wasn't.
She says it was not. So she is she's attempting to do recovery on her own, but of course, community corrections made it possible for her.
Violation with cocaine.
I'm sorry?
This is her third violation with cocaine.
Apparently so.
Yeah, that's a problem.
It is a problem, but I think a tether would definitely take care of that problem.
I don't have a tether that reads cocaine.
Well, that's what I wasn't sure when she suggested it, whether that was feasible. She seemed to think it was, but I don't know.
She who?
My client.
Of course. She's going to tell you that, and then she's going to go out and use cocaine.
Oof, this judge is done. You can hear the skepticism drip from every word. She's going to tell you that and go out and use cocaine. That's not just frustration, that's a bench warning. It tells us the judge has heard this same excuse before, too many times. This is not a rookie defendant, and the court knows it.
Use cocaine.
Well, maybe she just doesn't know. I didn't know.
She does what drug addicts do, and they tell you something that's not true.
Well, I don't know that she's truly an addict because her use has not been that frequent. But at any rate, I totally agree with the court that she can't be using cocaine, and I think she also agrees, and she understands.
At what point did that dawn on her?
Okay, be honest. How many second chances should someone get? First violation in January, then March, now again. The judge is basically saying, when did it finally click? You can feel the sarcasm and the exhaustion. Drop your thoughts. Below, should the court draw the line here, or give her one more chance?
I'm sorry?
At what point did that dawn on her? When we ordered that she couldn't use illegal drugs? In January when she tested positive? In March when she tested positive? Or this time when she tested positive? Which point did she all of a sudden figure out she can't use it?
Well, she should have figured it out beforehand, Your Honor, but she now tells me she has figured it out, I guess you could say.
I always hate asking, but I'll ask. Why not? I'll bite. What this time made her figure it out?
Well, maybe she's come to a realization that it's not a good thing for her. I mean, she's brought it up in the group sessions that she's had, these weekly group sessions, and I think they've convinced her that she has to cease her friendship with her old friend because obviously it's not a friendship that's furthering her best interests. And she tells me that she is going to do that. So I hope that she has come to a realization of how damaging to herself.
So, after a spiral of excuses, parental appeals, and tether talk, Molly's legal team claims she's finally realized the damage. But is it too late? Because right now, the court is preparing to drop the hammer and no amount of insight can erase 3 cocaine violations. Let's see what happens next.
To herself that this is.
I'm going to adjourn the probable cause conference in this case to June 5th, 2025, 9 a.m. Because of her violation, defendant's bond is revoked, defendant is remanded.
Thank you, Your Honor. That's it for me today.
And there it is. Bond revoked. Case adjourned. The judge didn't buy the excuses and, frankly, after 3 violations, who would? Molly's journey from voluntary recovery to courtroom regret is a tough watch, but it's also a stark reminder. The justice system does give you chances, just not endless ones. What did you think of the ruling? Was it fair? Could the judge have handled it differently? Drop your thoughts in the comments. And if you found this case as revealing as we did, make sure to like, share, and subscribe for more no-nonsense courtroom breakdowns. We'll see you next time, same courtroom, new drama.
That's it for me today, Your Honor.
Take care.
Yeah.
Happy birthday.
Thank you, sir.